Litigation and Appeal Partner, the matter of Peiris and First Tier Tribunal and others.
Yes, good morning. Good morning.
Good morning, my Lord. In respect of the question of funeral expenses, funeral payments, I communicated this to Ms. Braganza last night. What I'm about to say comes, I have two clients. One is the Criminal Injuries Compensation Authority, one is the Secretary of State. This comes from the Criminal Injuries Compensation Authority. In essence, a claims officer will make a new decision on the funeral expenses. It will require some administration, in particular because we weren't sure, and it's just been clarified this morning, who actually made the payment. It's been clarified that it was Pramod, who is the brother of...
Brother, yeah.
So, in light of that, we will commit for it to go before a claims officer. It has to be a claims officer who, under the Act,
yes,
and the scheme makes a decision. Because it is Pramod who has made the payment, purely for questions of administration, we will need a new application to be made, a new form. My instructing solicitor from the CICA has given her details to the applicant, the claimant, appellant, instructing solicitor, and they will be in touch with how this claim progresses. We will not be taking any point on time.
Thank you.
Nor will any point be taken about residence. But a claims officer will need to consider.
Yes, it's public money and it has to be done properly. Yeah.
Well, the 2,500 is automatic, isn't it? But they'll have to see whether it was reasonable if they're going to go above that.
Yes.
Yes, and there's also an issue over the fact that some of the payment is in Sri Lankan rupees.
So the translation needs to be done.
The other point I should raise, obviously, there are other issues in terms of eligibility potentially, in respect of there are other reasons why someone might not be eligible. That goes to the character of an appellant, the character of the deceased or previous convictions. However, Ms. Koska has very helpfully forwarded me a police report from the incident, which makes it clear that the deceased was blameless and also didn't have any previous convictions. So
that should not be a difficulty. Very well. Well, before I just go back in a moment to Ms. Braganza to get her perspective on this. Firstly, it seems. Thank you very much for taking those instructions. It seems on the face of it to be very constructive, and I imagine that as part of any disposal of this appeal, what you've told us could be neatly recorded as a recital to any order, so that everybody is happy, that they know where they stand. And clearly one of the, I have no idea what the costs implications are of the outcome of the appeal either way, but one of the consequences of this would be to remove this issue from any cost, in the sense that any reward might be vulnerable to recoupment for one reason or another. As this is not it would be a payment which is being taken outside of the proceedings, then it would, I hope, be possible to make sure that it was protected, in as much as it would have been had it been granted in the first place, assuming it was granted. If it isn't granted, the problem doesn't arise. You follow what I mean?
I do follow.
Right. Well, would this be a convenient moment for me to ask Ms. Braganza? Thank you. Ms. Braganza.
My Lord, so the first point is to make is that we're very grateful to Mr. Moretto for having taken instructions, and very grateful to his client for considering it in this way, and hopeful that it might be resolved relatively promptly. Mr. Moretto yesterday said it may be a matter of days rather than weeks, which would be excellent.
Well, that would be very
Yes, of
appropriate.
course. I'm not.
No, exactly.
I'm just highlighting that we are.
No, it's not. It's not. The
for-
intention isn't that it simply goes back into the system.
Exactly.
It will be looked after. Yes.
By saying this, I'm just highlighting and acknowledging that we appreciate that those efforts have been made.
Yes. I mean, we'll obviously take a little while to deliver our written decision in this matter, and it would be helpful if we knew what the
Yes,
outcome
of
had
course.
been before the judgment
Yes,
is given
of
out,
course.
because it's appropriate that it's recorded.
Yes, of course. We'll inform the court.
Thank you.
So that deals with the funeral expenses, and also we are grateful, my lord, you raised this matter of costs, and it had concerned us slightly, depending on the outcome, that the statutory charge, because our client is publicly funded, that wouldn't in any way
Well,
bite or be affected. But I think the way
I
in
think the
which
purpose
this-
of what I described as unbundling
Yes.
was to focus on the fact that under the scheme, if an award is made, it is made for the estate. And clearly there can be no recoupment as against the estate, because the estate is not legally aided, and so the provisions of full recoupment simply don't apply. The fact that inevitably, unless you wait for an estate to be wound up and find there's money in it, which might have not been the case here, somebody's got to pay the funeral
Yes.
expenses. And very appropriately, it was the deceased brother who did it.
Yeah.
And so, I hope I speak for us all when I say that insofar as somebody had to do it, that is an immaterial to issues of recoupment and who the money belongs to. It's simply a mechanism for it having been done. And because it was done in that way, it's appropriate it should be sent back to the person that paid it. But even if it was, for example, your client who had done it, what we're talking about here, as it seems to me, removes that payment from any risk of recoupment.
Yes, my lord.
So that's the intention, and I think the common intention here. And that means that we have, in effect, cleared the ground for our purposes in order to look directly at the bereavement award, which is what everybody had been doing hitherto.
Yes, my lord.
Right. Thank you very much.
Thank you, my lord.
Yes.
Just one other very minor point, whilst I remember I'm dealing with procedural matters, you raised the question of the civil procedure rules.
Oh, that interesting point. Yes.
Paragraph 52. Under 52(1)(3)(e), under the rules, a respondent includes any person other than the appellant who was a party to the proceedings of the lower court and who was affected by the appeal, and the person who is permitted by the appeal court to be party to the appeal. In respect of both my clients, the CICA and the Secretary of State, they were both parties to the proceedings below and affected by the appeal, and therefore they would be respondents. And I think probably the First Tier Tribunal would remain a respondent because they also
Yes.
would be affected.
Maybe even though they're not active.
No.
Yes. Well, I would like you to think that it was anybody on the bench that spotted this point. We have our judicial assistant today.
Yesterday afternoon I was about to move on to justification, and there are, in essence, three issues raised in the grounds of appeal. The first is whether the Upper Tribunal correctly approached the question of costs as a legitimate aim or justification. The second is whether they erred in not applying the weighty reasons requirement. And the third is whether they then erred in the approach they applied to the question of justification. Now, much of what I'm about to say repeats some of the questions of that were raised in the analysis argument and the analogous position situation. But frequently, whether someone is in an analogous position or not is the other side of the coin, whether there is reasonable and objective justification.
Isn't the modern approach really against knocking people out at the status stage if the issue of status is reasonably debatable, and getting to grips with the justification stage. I mean, if for no other reason than if a decision was wrong in relation to status, you still have to do justification in case.
Yes, I mean, yes. Cases are infrequently excluded on the basis purely of analogous situation or status, and they are sometimes, Carson is a good example of it. But in other cases, and it will be necessary to be determined by law to look at justification anyway, because I say the question of whether a difference of treatment is justified is very closely linked to whether people are in an analogous position or not. There obviously will be other reasons. Simply being in an analogous position doesn't mean the difference of treatment is justified, but it is clearly very important.
Well, I don't want to shut you out from making any arguments you want, but I think it seems to us that whatever the outcome on justification is, that the weight of the argument is focused on that point.
What I will do first is the question of cost, finances, and the Upper Tribunal. I turn to my skills and arguments as paragraph 58. I set out there the reference from the Lord Reed in the Supreme Court, the SC case, in which the Supreme Court emphasised that in the context of welfare benefits, the sound management of public finances, ensuring the economic well-being of the citizens. That is further set out by Lord Reed in JS, paragraph 63 to 64, and that's the specific reference citation that the Upper Tribunal relied upon at paragraph 64 of its decision, under page 96. Before coming back to that, I just want to refer to a few other cases in which costs are, in our submission, clear as a legitimate aim, both per se in themselves, but also as part of a wider legitimate aim of limiting funds to those with a sufficient connection to the UK. So, for example, if one goes to Carson, which is in Bundle 1, tab 4.
Is this paragraph 60? Essentially rehearsing the authorities that you've given us helpfully in paragraph 60.
Not this specific point, my lord.
All right.
That's a further point about the wide ambit. This really comes to the question of costs and finances. So, Carson, tab 4, page 59. And this is under the heading parliamentary choice. But what Lord Hoffman does in this paragraph, in my submission, is make it clear that actually when we are dealing with the distribution of funds, of limited funds, in essence, the decision will always come down to cost. He says at the end of paragraph 25, to say that the reason why expatriate pensioners are not paid the annual increases is to save money is true, but only in a trivial sense. Every decision not to spend more on something is to save money to reduce taxes or spend it on something else. And this goes to the distribution of resources, and it's important in this case because, as the Upper Tribunal itself said, as is the fact, by making a decision not to spend money on an unquantified expenditure, one can then use resource to put into other matters, and in particular in terms of the complementary compensation scheme, compensation to other victims, but also other means of support for victims, and that was part of the 2012 reforms, which I will come to. Now, I say Carson would because people outside of the scope of that social solidarity outside of the UK, because they're outside of that scope, then they weren't in an analogous position, and therefore justification wasn't required. Any detailed justification wasn't required. But if we go on to, well, what if justification is required? One then goes to.
So just pause there. You've talked about using the resources for other victims and other types of victim support, short of payments of money. Is that the same as, or is it separate from sustainability? Because some of the material seems to indicate that they were concerned about the amount, the total amount of the scheme. I think it's 200 million and was said to be more than any other European country. So is sustainability the same thing or a different thing?
So there were two issues in terms of the 2012 reform.
Yeah.
There was making the scheme sustainable by cutting the cost of the scheme going forward, so it could be sustainable going forward. But there was also a reform package intended to take away the burden of providing resource for victim support from the taxpayer and putting it onto the offender through increases in victim surcharge, when victim surcharge would be payable and an attempt to get more compensation orders. But also by putting more money into support services, victim support services in the UK. And one of the things it mentions in the consultation is that support services, those sorts of support services, would be much more available now, and should be more available now than they were back when the scheme was.
So I've understood it. Taking the publicly funded element, not the victim surcharge, but the publicly funded element, the aim seems to be twofold: reduce the total amount so it's sustainable going forward, and to reallocate within it priorities.
So the second authority is Elias, which is an authority relied upon in the Court of Appeal, wasn't relied on below, but it's an authority under the old Race Relations Act now, the Equality Act. It's a tab 5, and the relevant part is page 116. And this Elias related to compensation payments to victims of internment by Japan during the Second World War. And the relevant part, page 1, paragraph 144, at page 116, Lord Justice Mummery. I think that the question of legitimate aim has to be looked at in the round. In my judgment, the right was right to conclude the overall aim of confining the payments to those with close links to the UK was a legitimate one. The real question is not about the end to be achieved, but the means by which it was achieved, in particular whether Berthling criteria were a reasonable and necessary proportionate way of achieving that aim. Goes on to make a number of points about whether it was or not. And so, although the argument is made there that costs, the limiting of costs, and the reason why costs weren't in that case applied to those who didn't have UK nationality, the Court of Appeal said that is not the whole of the picture here. The whole of the picture here is that the legitimate aim, looking at in the round, is that it is right. It is that finding payments to those with close links to the UK is the legitimate one. Then one goes to JT. So this is now into bundle 2. I observe in passing, just for reference before we get to paragraph 34 TGRA, that was to do with...
So which tab, first of all, let's get it. Do you see bundle 2?
Yes, bundle 2. I go very briefly TGRA, which is tab 9. I'll simply give you the reference to TGRA. I'll go to JT, which is at tab 12. Apologise. The reference to TGRA is paragraph 34, page 280. And that case involved benefits for education secondary, tertiary education, and it was accepted there that having a close connection with the UK was legitimate in terms of deciding to whom resources would be paid. I haven't taken you directly to it because it was accepted in that case, but again, that underlines connection to the UK is well accepted and established criterion for limiting public resources. So JT, paragraph 113, the court's already been taken to this in some detail. And although the Court of Appeal found that in that case the justification was not made out because in essence there was an arbitrary distinction as between an arbitrary and unfair distinction as between the victim who lived and was more seriously assaulted with the abuser who would not receive compensation, whereas someone who was less seriously assaulted and didn't receive the abuser did receive compensation. But underlying that at paragraph 113 is that put in terms of proportionality, saving a potentially significant and uncertain cost is undoubtedly a legitimate aim. And the same rule is at least causally connected to that aim. And so again, the Court of Appeal recognises that the saving of an uncertain cost is undoubtedly a legitimate aim. The Court of Appeal goes on to say that can't be done on an arbitrary and rational basis. But the underlying principle is it is a legitimate aim.
Whilst you have JT there, and I hope it's not taking you out of your order, can you give some assistance on where we are standing back from it on the test? Paragraph 84 spends a lot of time asking whether or not you go through the 4-stage test ending with reasonable, with fair balance, and when you get to fair balance, it's not manifestly unreasonable. And then we've been shown other cases, possibly later, possibly earlier, which seems to talk solely about manifestly and without foundation in the context of economic policy and social resource allocation. So what's the test? Is it 84 of GT or is it SC, or do we do both because we don't know?
The test is SC.
SC.
So I can take you to there now. Actually, before doing so, because SC is in the next bundle, I'll just take you to SANE, which is in this bundle, which is at page 443, tab 15. And if one looks at page 559, sorry, 459, paragraph 32, whilst we're there, and I'm not going to spend a huge amount of time on status, but paragraph 31 sets out at the top of 459, discrimination on the basis of immigration status is of course a fundamental and accepted part of national law, but cannot give itself give rise to issue under Article 14. It requires a claimant's differential treatment arising from status as a third country national. I have no complaint. In Zambrano status, that's clearly law. Such differences of treatment there are compared to other countries' residents, more than reflect the law by which the state is created. So that goes to the question of whether there is an independent characteristic as part of the status mission. Moving on to the question of justification. In any event, the Strasbourg Court has long accepted that the allocation of limited public resources in social security and welfare context is preeminent in national authority. It carries on after reference to MA. The government's reasons for not providing support to Zambrano carers, as explained in the evidence of Mr. Cooper, included the objective of reducing costs by allocating allocating benefits to those with the greatest connection with the country. Turning then to FTC and an number of questions in respect of the correct approach. The correct approach is best set out paragraph 143, the approach of the domestic courts. 143 sets out that the domestic courts have generally endeavoured to apply an analogous approach to that of the European Court. And then at the top of page 797, accordingly, where the European Court would allow a wide margin of appreciation related to policy choice, the domestic courts allow a correspondingly wide margin for discretionary area of judgment.
Yeah, the specific question I had in mind was this. You can do it in two different ways. You can say to yourself, is this policy choice manifestly without foundation? The alternative way, and the way that we've been invited to do it, is to go through what's the aim, is it rationally connected, were there less intrusive means, and fourthly, and significantly, does it strike a fair balance between the individual and the community interest? And JT went down that route and said when you get to the fourth element, fair balance, it is no longer a question of manifestly without foundation. That applies to 1, 2, and 3. But when you get to a fair balance, it's for the court to strike the fair balance. And it's a very, very specific question whether that is correct or whether JT and what Lord Justice Leggett says about that has now been overturned or overruled, or because JT wasn't referred to in SC.
No, the approach, correct me if I'm wrong in misunderstanding the question, the approach in SC is that all other things being equal, a wide margin of appreciation is given to the legislature at that justification stage, at that balancing stage.
So we don't need to worry ourselves about asking whether or not there's a fair balance comparing the interest of the individual and the reason for the policy. We simply ask whether the balance is without manifest foundation.
Yes. So paragraph 161, I'll ask you to read that. So 161 let's see.
Page 801.
Yes, page 801.
Thank you, very helpful. Yes, thank you.
And 157 to 160. Before that goes on to the question of when does the manifest without reasonable foundation approach apply and when doesn't it apply. And so 157 says, I'm not persuaded by the argument based on JD that the manifest without reasonable foundation formulation can never have a part to play, even in relation to differences of treatment on suspect grounds outside the context of transitional measures. 157, nevertheless, it's appropriate the approach which this court has adopted since Humphrey should be modified in order to reflect the nuanced nature of the judgment which is required following the jurisprudence of the European Court. And then goes on to set out what that nuance will be. In my submission, unless there is a very clear indicator saying that this is the case in which weighty reasons are given, where it is a matter of welfare policy, a question of deciding to whom resources should be divided up amongst those who may be in need, and where it is a matter that Parliament has reviewed, then it is the wide margin of appreciation that is applied, and that's actually exactly what happened in A and B, which was handed down on the same day. So So just in terms of connection to the UK and costs, costs is a legitimate aim. The saving of costs is a legitimate aim in respect of welfare policy, as is the decision to limit benefits to those with connection in the UK. And that's that's certainly in essence what the very clearly what the First Tier Tribunal found, but also in essence what the Upper Tribunal found and applied. So if one goes to the Upper Tribunal judgment in the court bundle at page 99. And paragraph 64. The resident requirements were introduced in an attempt to save costs, references sufficient connection to the UK and such like an essential degree of connection, which the government is appropriate to spend resources on. There's nothing intrinsic in being a victim of crime that otherwise makes such a connection necessary, and is noted by both predecessor schemes and the convention the directive on basic territory where crime occurred. Nevertheless, saving costs in order to provide a compensation scheme and given the wider reforms, other services to victims of crime is in my judgment of this. And then paragraph 83. Again, the reference to connection to the UK being a way of attempting to save unknown costs in a way that would presumably be considered politically acceptable. However, approaching it on such a basis still seems to me to have that some kind of residence test is proportionate and unobjectionable. It can be found in reaction to many mainstream social security benefits. So that's, let's say, connecting to the UK for residence requirement and the in so applying seeking to save costs and to limit public expenditure is all properly, as I hope I shown by the authority, a legitimate aim. In terms of the appellant's argument that one should be applying a
Before you close that, I know you're going to go on, but you remember earlier on there was discussion during Ms. Braganza's submissions about the extent to which the design of the scheme took account of the rather the very different considerations that might be said to arise as between a living victim and somebody seeking a bereavement payment. And then this is where we got to, which is paragraph 84. I'll interrupt you at this stage because that's where the judge sees this as being, as he puts it, more debatable. It is it not? I mean, if one was zeroing in on this particular situation, which is, I appreciate, not what was being done when the scheme was being devised, there must be a question as to whether any particularly close attention was given to the qualitatively different circumstances of those who are bereaved and those who are injured. That's the point that is arising here, is it not?
If we go to the scheme itself, and now might be a good time to take you through the scheme and to show that actually in terms of when the scheme was devised, the connection with the UK was very much perceived to be of the applicant, and it's the applicant who is making the application for the funds, the taxpayer funds, and it's their connection that is therefore important. And therefore, there is a qualitatively different, perceived there as being, and intended there to be, a qualitative difference between a dependent who has a connection themselves, because the dependent who is making the application, there is a qualitative difference between the dependent with the connection to the UK and the dependent who doesn't have that connection to the UK. So if one goes to the scheme, I was going to take you through this in any event when we come to the third round, which is the application. So if we go to consultation papers and a supplemental bundle and a quick.
Yes. Well, you might. Do you want to start with just giving us the references, because we've presumably seen all these already, have we?
Most of them.
Right. Well,
So page 4 and 5, which is the forward.
yes.
You've seen that. If you look at all of it, there are references, for example, at the top of page 5 to the Secretary of State, Lord Chancellor's Secretary of State's plans to maintain the overall levels of spending on victims, with increasing sums available for the vital area of practical advice and support. And so that is the point that I was referring to when my Lord Justice Lewis asked a question about the saving of money, and part of the overall, to put money into other support services. The two paragraphs at the end of page 6 also deal with the troubling situation of the criminal injuries compensation scheme at the time. One then goes to page 50, and this deals with the paragraph 169 and 170 deal with the underlying nature of the scheme we've already seen in some of the authorities. Compensations given to victims of violent crime and recognition of a sense of public sympathy, the pain and suffering of the victim. And then paragraph 170 refers to victims can also apply for payments of loss of earnings and special expenses. The maximum overall award that someone can receive from the scheme is capped at 500,000. The scheme also makes awards to dependents and bereaved of fatal cases. And again, although this particular case is not, it doesn't deal with other elements of dependency awards. The limit for a dependency award is, as with claims by victims, £500,000. That's set out in paragraph 60 at page 40 of the scheme in the authority bundle. So page 40 of the authority bundle. So there can be potentially large sums being paid to dependents. In terms of reforming the scheme, there are 5 bullet points in terms of number of principles. The third bullet point is important at page 51, consideration of alternative provision. So our proposals take into account the availability of other services and resources and state benefits the victim may be entitled to meet the needs arising from the injury. So again, that shows the interlinking nature of the scheme and other resources available. The next bullet point is important, again, making the scheme simpler and easier for victims to understand. Clarify eligibility criteria and evidence victims need to provide to make an application to the scheme. Again, that's important because of all the authority that talks about A and B being the most obvious ways it applies to the scheme. The need for rules to be clear, and that doesn't necessarily mean there will be some people that fall either side of a clear dividing line. And then the sixth bullet point, ensuring proposals comply with our legal obligations, both domestic and European. And that is obviously important because that is where the reciprocal arrangements in respect of citizens of the EU and convention states arise. And then under the high-level proposal, paragraph 174, a high-level part of the proposal under eligibility is that about restricting eligibility, applicants should have a connection to the UK which is more than temporary. So the First Tier Tribunal was right when they said that it is actually a major feature of the scheme. scheme that the connection to the UK requirement. The connection to the UK requirement is then set out at page 58 to 59. Just a couple of important points to point out. One is obviously the initial proposal, the consultation, was that applicants had to have been resident for 6 months, and in due course, following the consultation, that requirement was lowered in response to the responses to the application.
Just going back to the point you last made, you say the paragraph 174 speaks against the UT judge's conclusion that this was simply about money.
Yeah.
Because your position is that it's both about connection and money.
Yes.
Right. And so the fact that one tribunal went with one and one tribunal went with the other shouldn't, in either case, be regarded as a full answer.
No, and even the Upper Tribunal even the Upper Tribunal didn't wholly go with cost because the Upper Tribunal still makes the references to the residence requirement being an accepted part of welfare benefits, as is clear from cases like Castle. So, I say the reality of the situation.
Well, the fact that cost is a driving motive for reforming a scheme doesn't mean it's the only motive for reforming a scheme, because the original scheme had some motives that are intended to persist.
It's really both, isn't it? You want to have an expenditure that's sustainable, and one way of doing that is by drawing tougher lines on eligibility, really.
Yes, I mean, that is the essence of it, and the way that is done is through ensuring that there is a sufficient connection to the UK.
The lines on eligibility are, on this account that you're presenting to us, intended to be reasons of their own, namely that is what the scheme is for, not just what it costs.
Yes, it is what it is. I say it's two parts of the same thing. It is what it is for, because it is a scheme, a benefit scheme.
I mean, the need to save costs might be a prompt to think about what the proper aims of the scheme are, and you can consider it a number of different ways.
But you're moving from one to the other. In the past, before this scheme, you were not concerned with anything other than the location of the crime. Now, because it's 200 million and you're worried about it and you want to reorder it, you've decided we've got to go back and cap the costs or reduce the costs. And one way of doing that is eligibility. Whether you would have done the eligibility if you hadn't been worried about money is an interesting question. And we don't know. They do seem to be linked, don't they?
Yes, I mean, yes, and I think that was the Upper Tribunal judge's view, and our position is they are linked. That was clearly a driver for one of the forms was reducing costs, and the question is that a legitimate aim? Yes, it is, but also is the requirement to have a connection with the UK a legitimate aim? Yes, it is, because it is a welfare benefit and a measure of social solidarity, and that's a fundamental question: is it are they legitimate aims, and then are the means proportionate to meet those aims, giving the legislature the appropriate margin of appreciation. And just so in terms of connection to the UK, the other point about page 58 and 59 is that fatal cases are included within that part of the consultation at page 194, which is
Paragraph 194.
paragraph 194, page 57 of the bundle. So again, I mean, in terms of how this was considered, again, it was considered that it was the applicant who needs the bereaved family who needs to show that residence requirement rather than the person who was deceased.
Yes.
Then, and again, that was the original proposal. The response is then at page 109 of the supplementary bundle, which again, as we've already seen, then limits the previously more strict residence requirement in light of the responses by changing the policy so that there's really an ordinarily resident requirement. Then we haven't really looked in any detail at the impact assessment. So there are two impact assessments, one in January and then one in July. I'll take you to the July one, because that's more pertinent, which is at page 210, or rather past at 210 of the supplementary bundle. And we can see under the very large box that runs from page 210 to 211 all the various different amendments, changes to the scheme. And each and every one of these has a cost implication. Either increases cost or reduces the cost. And this is a good example of the government balancing the various different competing measures. So under B, at bottom of 210, is the policy option of excluding those who cannot show their ordinarily resident at the time of the incident in the UK, with the exception of those exceptions are set out. Let's say this is just one of a number of other amendments to the scheme in terms of the types of crime that would be included under A, in terms of over at 211, in terms of reporting to the police at C, in terms of unspent criminal convictions at E. The whole range of, there are then amendments that go to the actual awards that are made rather than eligibility. So it is important to make clear that this is one part of an overall package of reforms. Then at 213, we see the in terms of saving the cost of the scheme as a whole, in the first box, the total reduction in payment estimated around 35 to 55 million a year, in real terms 46 million. That is the intended cost savings overall. But in terms of this specific issue, there's then sort of detail about the evidence base. One can see at page 218 in the box there again, the reference to the payment victims of violent crime, excluding those who cannot show their residence. And the you'll go to 228. There was a mention yesterday about the £0 to £2 million savings to victims of who had unspent criminal convictions. But that's not this case, but it's a saving that could be estimated. And then in terms of other costs, we get to 229, non-monetised costs, paragraph 59. So there are several policy reforms where we do not have any data to enable us to monetise the impact of victims. In addition, we've identified some of our reforms and costs for other organisations. So under 59, cost of victims who do not satisfy the requirements for ordinary residents or exempt from it. These individuals will lose entitlement to compensation for crimes of violence committed in Great Britain. As there are currently no requirements relating to residents in the scheme, no information is held that could be used for an estimate, so we're not able to quantify the impact of this reform. And then if one looks at footnote 44, there's a reference to CICA receiving 254 claims from individuals with addresses outside of Great Britain, of whom 160 received compensation. But again, says that these figures are not accurate because we don't know whether they came from British or EU citizens. So what there very clearly is an assessment and a consideration of what firstly, a consideration that applicants for dependency claims must themselves have that connection, and an assessment of, an attempt to assess what that is cost. And it, as set out, couldn't do so because it didn't have figures. But that doesn't mean, as set out in JT, clearly it's legitimate to limit potentially unquantifiable sums, and that is what this case was. Just very briefly, in reference to, there were also equality impact assessments. And
Just before we leave that figure, I mean, they're not saying 908,000 is likely to be the maximum, because it's perfectly possible, not just that it'll include EU and UK nationals who would still get it, but presumably it's possible that people could apply with a British address. Quite understandably, the appellant here applied, because they don't treat it as a likely maximum. They say it's not a useful guide at all.
yes.
Yep.
And so just in terms of equality impact assessment, and just for reference, this was considered in detail, the impact of the scheme generally at page 287 of the bundle, deals with eligibility to scope of the scheme, and in particular connection to the UK is at page 291. Paragraph 69, we believe that applicants to the scheme should have a connection to the UK.
This is part of the same document.
So this is part of the equality, well, so this is the equality impact assessment, part of the document that I referred to at page 287.
Yes.
It's a different document to the economic impact assessment that we were going to previously.
So we're at paragraph 70.
Sorry, paragraph 69 at page 291.
Thank you.
Again, paragraph 69 sets out the consultation proposal, and paragraph 74 sets out the legitimate effective bereaved relatives at the top of page 292. Then sets out the post-consultation decision from paragraph 76 onwards. Then analyses the impact of that, we can see from paragraph 80 onwards in terms of race. And then deals paragraph 90 with equality issues raised during consultation. Paragraph 90, concerns about proposed eligibility may impact victims of ethnic or religious minority background. And then under mitigation and justification, paragraph 95 onwards deals with the mitigation and justifications for the decision. And set out as part of that, and part of the reason for that, the government have relaxed the previous residency restriction to enable more people to be able to claim. But again, sets out its mitigation. The revision of the policy will benefit those who arrive here, this is paragraph 97, and can show a settled purpose for their being in the UK at the time of the incident, including some students. Those who have to satisfy the residence will no longer have to have done so for 6 months. This is more proportionate to exclude fewer people from the scheme while still maintaining the underlying policy of connection to the UK. And that answers the point about the two Americans, one who is intending to be resident and the other isn't intending to be resident, was raised yesterday. Now, what there isn't is any separate consideration of any particular impact on dependents of victims, as opposed to victims and dependents all wrapped up in one. But the reality, and the practical reality, is of compensation schemes of welfare benefits is there are all sorts of issues and matters that government look to and have to consider a number of different policy proposals. The position of dependents is clearly considered within the question of victims. eligibility for victims and applicants. Essentially, it's all encapsulated within the word applicant, the eligibility for applicants.
So if you were a non-national, non-resident dependent of a deceased person, you would be excluded by the scheme to much greater consequence, in fact, certainly in monetary terms, than a bereavement award.
Yes. Yes. Because so if you are living in a country, say in South America, and you're
Well, remittances. Let's suppose you have somebody working over here and sending back remittances.
Yeah.
Then that person would not be eligible under the scheme, and it's, as it were, in a sense, a harder example than even the present case.
It may, I mean, we're not dealing with, there's no application for a dependency here because the appellant...
No, I was just looking at the scheme.
But it may be harder to justify dependency being restricted to those outside, because the key factor for dependency is that you are dependent. Just as in JT, the problem was she was in the house, and the scheme was meant to protect victims of crime. A dependency is meant to protect the dependents, and you may have a difficult or more difficult hurdle to show justification where somebody is actually dependent. The person was here, they died here, the person abroad is dependent here, and you're saying even though you're physically dependent on that person or financially dependent, you're not going to pay it. But here we're only dealing with the bereavement.
well, that case can perhaps be addressed when it arises, but we would say the same principles apply, which is that this is fundamentally, as of course said, a scheme of social solidarity, and international law recognises that they are essentially national in character, and therefore, although it is sad and gives rise to terrible difficulties of people in other parts of the world whose relatives have come over to the UK and are sending money back because of a crime, that money is no longer can be sent back and can put that family in terrible difficulties. It falls outside of the sort of national scope of.
Well, that would be your case when you get to it, but it's different from a bereavement, which is a straightforward payment and recognition of the event. I mean, the scheme is financially or physically dependent. It includes carers. If a carer came for a week's holiday here, whilst the person that they're caring for went into respite care and the person was killed, the person who's physically and financially dependent still can't get anything. And then you may well ask whether or not that really is a JT contrary to the purpose of the scheme, or whether you're right to say, nonetheless, if you're not resident, your own problem, not this country's. But we're not in that.
Really, I'm grateful for that to that particular case. So, in essence, therefore, both looking at the scheme and the authorities, we would say that the Upper Tribunal and indeed the First Tier Tribunal was right. And it certainly cannot be said that this is a scheme to which detailed consideration hasn't been given, because it clearly has. And they are certainly right that insofar as, whereas it is not possible to actually predict what the savings would be, it is legitimate to seek to save money in that way. It's legitimate to seek to limit payments to those within the UK, and it's important that the decision makers, the executive and then Parliament, who approved, both Houses of Parliament who approved the scheme, is given appropriate respect. Now the one final issue is then Gagezu's argument to say, well, this is all about nationality, and therefore a high degree of weighty reasons are required. I deal with this really at paragraph 67 of my submission. I deal in particular with same rule applies to the two other cases that are relied upon by the appellant, which are Suarez and Mariol. Jacobs is a very, very different case from this and came before Carson and well before Carson. The difference being that the facts of that case make it quite clear that the applicant, Mr. Jacobs, who was a Turkish national, had been resident in Austria from, facts are set out at the authority bundle 3. Page, so that tab 24, page 856. Mr. Gagazou's, the European Court of Human Rights was very specific with the dates here in terms of putting out facts. He was in Austria from 1973 until September 1987. He worked without interruption from 1973 to October 1984, was then unemployed and claimed an advance on his retirement pension from July 86 to March 1987. That ran out, and he therefore applied to the Linz Employment Agency on the 6th of July 1987 for an advance on his pension in the form of emergency assistance. On the 8th of July 1987, the agency rejected his application on the ground that he did not have Austrian nationality. So that is the essence of the fact of that case, although he later moved back to Turkey pretty soon after this. At the time of the application, he had been in Turkey, in Austria, and resident in Austria for some 15 years. And the reason he was excluded was because he didn't have Austrian nationality. The other two cases upon which the...
Sorry, can we, before we do that, the impression I've got about Gagos is if you look at page 858 and the reference to other qualifications, it's said to be under section 33, for a grant to be made, they've got to be Austrian and fit for work and in urgent need. So they may not meet the other ones, but it is a key requirement that you've got to be Austrian, or have I misread the fact?
Yeah. There's a slight exception to that, or an extension under 3. The requirement of Austrian nationality is not applicable.
Oh, I see, yeah.
Been uninterruptedly resident in the present territory since 1st of January 1930, or to persons who were born after that date in the present territory and have subsequently been uninterruptedly resident there. So there is an exception for those who have been resident for life uninterruptedly, or resident since before 1930, so some 27 years.
That's like permanent residence, is it?
Yes, well, it's certainly resident uninterrupted, which is very different from this case, where the essential requirement is one of residence, and therefore applies to individuals of all nationalities and national origins who are entitled to compensation because they are ordinarily resident in the UK. And to suggest in this case that the appellant, Mr. Peiris, was used compensation exclusively on the grounds of nationality is simply contrary to common sense, logic, and reality. And the same is true in respect of Juarez, who we can see at tab 26 is page 895 is a national of the Ivory Coast, or was at the time of his application for disability benefits. So he was an Ivorian national and was adopted by a French national. At page 898, we can see at paragraph 9, he lives in the Peiris region. And the reason that he was refused compensation is because of his nationality. That was the only reason. So, and one could see arguments before the court, paragraph 43. The government submitted the applicants for case of discrimination still founded. They point out the distinction made prior to the 1980 Act between nationals and foreigners and awarding the allowance for disabled adults to the balance of state of their income and expenditure. So that's the reason for the difference in nationality, and that would not have to be a sufficient justification. And again, to note, and it's also something that is mentioned in paragraph 49 of Peiris. The court finds the arguments advanced by the respondent government unpersuasive. The difference in treatment regarding entitlement to social benefits between French nationals and nationals of a country having signed reciprocity agreements and other foreign nationals not based on any objective justification. Even though material time are not bound by reciprocity arrangements with Ivory Coast undertook and ratifying the convention still along with this jurisdiction, which the applicant involved by defined in section 1. So again, it's a different situation because unlike the situation in passing, where court makes claim that benefits are essentially national in character, this person, Mr. Peiris, as Mr. Keikasus, and indeed as with the Pomeroy family, were all seeking benefits within the state. And then finally, Ponomaria, which is at tab 30. This involved education and the fact that the applicants who were Russian nationals had to pay school fees, whereas Bulgarian nationals living in Bulgaria didn't. And again, the fact is they are within Bulgaria claiming benefits as residents of Bulgaria. And paragraph 54 at page 1027. The court says, having just clarified the inquiry, the court starts by saying the state may have legitimate reasons for curtailing the use of.
Shall we read that paragraph? Yes.
So the court there is clear. One is that there may be legitimate reasons for curtailing public services, resources on public services. Two, it may also be justifiable to differentiate between different categories of nationalities residing in a territory.
Can I just understand the fact, is this a case then which is like our case? You will get the fees paid by the state if you're a national of that state, or if you're a national of a different country but are permanently resident in that state. Are those the facts? Because that does sound like ours.
Domestic law, so this is H2, provided that only Bulgarians or those with permanent resident permits were entitled to free education.
And so you could get it by one of two routes, and the reasons why they didn't get it was they didn't have the requisite resident status, not nationality status. If you read the report, they got residence permits, and from the date that they got it, they weren't required to pay fees, but they were required to pay fees for a period when they didn't have the resident status, which is residence, not nationality.
Well, the the court at paragraph 54 makes it clear that justification is available where people are treated differently within a state.
Mm-hmm.
They also make it clear that they justify to differentiate between different categories of aliens residing in its territory. For instance, preferential treatment of nationals of member states of the European Union, some of whom were exempt from school fees, may be said to be based on an objective and reasonable justification because the Union forms a special legal order which has moreover established its own citizenship. Yeah, so, I mean, in terms of the, what the court then does in terms of deciding what level of scrutiny, we can see that paragraph 58. So it's these considerations militate in favour of stricter scrutiny by the court of the proportionality of the measures affecting the applicant. And the matters that it is dealing with, paragraph 55, this is addressing education, which is one of the most important public services. And so the principle that is set out in paragraph 54 cannot be transposed without qualification. So we're in a different field, the education field.
So the things that call for justice, stricter scrutiny, was the very important nature of the benefit issue, i.e. education. That's it, rather than the nationality of, or the residence of the people involved. Yeah.
I think that seems to be clear from paragraph 56.
Mm-hmm.
The state's margin appreciated in this domain increases with the level of education in inverse proportion to the importance of education for those concerned in society at large. And then deals with secondary education. So that appears to be the basis for the stricter scrutiny, having made it clear that a state can, in any event, treat nationals differently in certain circumstances. It certainly wasn't. This case certainly wasn't treated as a. Well, if we turn to SC, which looks at all of these cases, and one looks at.
Well, if you look at 60 to 64, this doesn't seem to be saying that whenever you've got a residence requirement, you need stricter scrutiny or weighty reasons. It points out the reasons why, given the education in that case, and given the reasons why these people were in in Bulgaria, the fact that they lacked a permanent residence requirement wasn't relevant. They'd been there, their mother was Bulgarian, they couldn't go anywhere else, and yet they weren't getting free education. So it seems to be a combination rather than a nationality equals weighty factors.
One goes to, finally, one goes to SC, which is at the beginning of this bundle, and the Supreme Court goes somewhat exhaustively through all the both domestic and European jurisprudence. And one looks, for example, at paragraph 105 of that at 784. The Supreme Court, Lord Reed, is dealing with the question of very weighty reasons and when will very weighty reasons be required. Paragraph 105. The very weighty reasons requirement was next extended to differences in treatment based exclusively on nationality. So again, Lord Reed uses the word exclusively on nationality. That case, like many later cases, concerned differential treatment on grounds of nationality was concerned with entitlement to welfare benefits, but predated the formulation of the manifesto without reasonable foundation test. Will be necessary to consider later for more recent cases of the same kind. And then Lord Reed goes on to say, even where we're dealing with nationality, there are nevertheless circumstances in which a wider margin is applicable to a difference in treatment based exclusively on the ground of nationality. He refers one there to MS in Germany, which is a question of extradition of non-nationals, which one thought might be self-explanatory. That it's justifiable to treat nationals differently
Yes.
to non-nationals.
I think we've got
The other one, the other point is Lord Reed refers to Morea not to say that was a case in which very weighty reasons were required because of nationality, but he actually refers to it to say that there are circumstances in which a state may differentiate between different categories of aliens residing in its territory. So our position is that this case is again different because there's no question of an alien person from another country residing. One question that was asked yesterday was about residence. There is a reference that I took the court to yesterday that residence itself is not a suspect ground. That's paragraph 125. Paragraph 114, another ground that is not a suspect ground for which weighty reasons are required is immigration status. You can see that paragraph 114 in the reference to bar. So in bar, the applicant was refused priority housing because of the immigration status of her son, and who was had been given leave to remain, and therefore was still under immigration controls. Now, if it's the case that one can extrapolate from a ground of treatment a claim of indirect discrimination based on nationality, then immigration status would be the obvious situation in which one could do that, because it would clearly only be people who aren't UK citizens who would be subject to immigration control. And therefore the fact that the Supreme Court highlights that the Court of Human Rights has said that immigration status isn't a ground that requires strict scrutiny again undermines any argument the claimant, appellant in this case, makes.
Yes, although immigration status might be in a special category in that respect because it's so obviously related to nationality.
Well, then we would say so with residence if one is. And I mean, and the other sort of more obvious point is if I say if and later this point perhaps enough, and I'll stop in a moment. But if it's an internationally acceptable feature of benefits legislation that they are national in character, then that is always arguably going to put people who aren't nationals to a disadvantage.
And you're not stopping people. I mean, there's nothing to prevent Sri Lankans claiming. We aren't saying we don't want people from the Indian subcontinent to claim. We are saying anyone of any nationality can claim. If you're of certain nationalities, you'll qualify automatically. So it's not as if we are stigmatising by reference to ethnicity, other than the fact that they don't have the nationality that allows them to stay here.
Where have we got to?
Well, that completes my submissions on justification. We say that the Upper Tribunal didn't err in its approach in saying weighty reasons weren't necessary. If weighty reasons were necessary, then same reason in Carson, different in the internationally accepted feature of benefits being domestic in nature is a weighty reason. Didn't err in its approach to cost or that connection with the UK as part of that can be a legitimate in our submissions for those reasons, the appeal should fail. I haven't addressed in any detail the question of status.
Picked up the.
Picked up as we've gone along. It's referred to in my submissions. One could look at this case and say it's a case the difference of treatment is based on residence. In which case we say plainly you don't need weighty reason. Plainly there's a wide margin of appreciation. Could be looked at and say, well, there is a difference in treatment of nationals. Again, we say by reference to, because of the reciprocity arrangements, by reference to Carson again, that would be a weighty reason for the difference. But what we say can't be done is to try to say the status here is comparing the applicant to someone who would qualify by all the various different routes. Because if you're doing that, you're then describing the discrimination by reference simply to the law which creates the discriminating against group, and that being the
yeah, but the way the status will come in is in this way. People who is the father of somebody who's killed in England qualify for a bereavement payment. If, and status comes in because they don't qualify, if for residence reasons. So you can't just look at part of it. You've got to look at the other bits as well, because a key component is there has been a death in the United Kingdom, and the person is a parent of that person. And if you start saying, and you're giving it to residents but not to non-residents, you'll never have an Article 14 case, because by definition the status is going to be included in the thing that comes. The building it into discrimination is when you say there's a difference between people who live in a local authority area X rather than Y, and there the only difference is the thing that gives rise to the difference of treatment. But here there are multiple factors necessary to give rise to treatment. Would you say that's wrong for the reasons you've given?
Yeah. Yes, I mean, we say, and I think my submission seek to make it, maybe they don't, but if you seek to, you could say that this is a residence criterion and just rely on residence, or you could just say this is nationality. But there are good answers to that. What you can't do is seek to build in the reality of the scheme is that it's a multifactorial approach in terms of who is eligible and who isn't, that there are people such as victims of trafficking who are eligible because of international agreements. And so there will be people, Sri Lankan nationals, who are eligible even though that they're not not permanently resident. You can't actually, in reality, when you're looking at what is the reason for the difference, when one's looking at the scheme, the reason is that multifactorial.
This is at page 41, is it not, of the core bundle. Paragraph 9 of your respondent's notice.
Yeah.
I don't know if I'm coming at it in the same way as my lord is, but it looked to me to be completely circular. I mean, you appear to be arguing that they can't be discriminated against because the reason they're not getting the payment is because of our rules. It doesn't take us anywhere. I mean, so insofar, I mean, unless you can help remove the scales from my eyes, we're not going to need a response on that point.
My lord, I'll leave those submissions where they are.
I mean, I appreciate you have other much broader submissions to make, but we want, I think, to focus on what the real nub of this appeal is about.
Yeah, no.
No. Anything else?
I have nothing further, my lord. If there's anything further.
Thank you very much indeed. Yes. Any responses?
Yes, if I may. I'd said at the outset that Ms. Koska was going to address the court, if need be, on the analogous position and status. Given the court's
Well, I think I should just consult with my colleagues before we give an indication about that.
Thank you.
It's disappointing to us, but probably not to Ms. Koska. But we don't need to hear on that point. It's not to preempt what we're going to say about it, but we consider that we know enough about that issue to deal with it satisfactorily.
Thank you, Mark. So if I may, the points I would like to make in reply are first of all to emphasise that whilst Mr. Moretto says that these measures are, and in this case, this is such an instance, blunt instruments, that there's a need to look at the system as a whole. And what I say in reply to that is that this case is about the bereavement award being a token, an acknowledgement of the loss that is suffered and an expression of support. And when Mr. Moretto addresses the court and says, well, it's about the community and nationals, and that's the thinking behind it. The point I make there is that, of course, in this case, it's not simply a question of a national or a non-national, or someone who's ordinarily resident or not. The point is that the victim was. So, to the extent that there is a reflection within the bereavement award, the community recognising and extending its support to someone within its community, that is what the bereavement award does, and that's why we say in this case it should be extended to the bereaved parent. The next point that I make.
So hold on.
So that the way you put it is that to be lawful, the scheme must tie the requirement for a claimant for a bereavement award to the status of the victim.
Yes, or the way that we put it in our skeleton was to insert the words that whereas the eligibility or
paragraph 55 of your skeleton argument.
Exactly. Well, the person, or in the case of the bereaved parent, the victim. So yes, and that's why I say it's not this binary situation of nationals or those ordinary resident and those not, as a reflection by the community. That would reflect what the scheme intends to do, because it is one of their own who was murdered, in terms of it is someone within their community. And that equally is a factor that feeds into the proportionality exercise in the context. The next, I don't say any more about status. Yes, on the weighty reasons and the indirect discrimination, on that, I take slight issue with whether weighty reasons are to be applied depending on the nature of the nationality. If by way of example, if a core ground is at play, say for example sex or race, then it's justification where it comes to considering the factors that are involved within it. There's not a qualification in terms of a variation on that core ground. And equally here, if you accept our point that nationality is one of the grounds, so one of the status, be it by a route of direct or indirect discrimination, then in turn, our submission is that weighty reasons are required to be made out, and that is when it's at that point in the exercise, on the point of justification, that then comes into play, whether it's in the context of education, whether it's in the context of a compensation scheme as we have here, or what the context is. That's how I put the need in terms of weighty reasons. And on that, if I may very briefly to the Upper Tribunal decision, please. Two specific paragraphs, and these tie in both to the weighty reasons and the indirect discrimination and the nationality point. The first is the way that it was put. If you go to page it's paragraph 52-53, it's page 96 of the core bundle.
The paragraph again?
So it starts with paragraph 51, Mr. Moretto making an argument that he repeats in his submissions to the Court of Appeal. And then paragraph 52, page 96. Ms. Adam counters that by submitting that it's nonetheless undoubtedly harder for a national of Sri Lanka or a person who's ordinarily resident in that country to fulfil the requirements than it would be for a British citizen or someone ordinarily resident. She relies on OA and then relies on DH. Discrimination may take the form of disproportionately prejudicial effects. And then the Upper Tribunal then says, I accept, paragraph 53, I accept therefore that the measure does treat the applicant unfavourably on the ground of nationality and or. So we rely on that.
Yes.
And then also taking that point further, in SC, which is at tab 22, if I may take you briefly, you've obviously been taken to it a number of times, but the paragraph, I don't think that you've been taken to paragraph 108, that's page 785 of the authority bundle. So SC 785, para 108. And so I rely on paragraph 108 in two respects. I'll ask if I could ask you to read that, please.
Certainly. Yes.
So what we say on that is whether the word exclusive is applied or significant or decisive. In this case, the reason that's what is being considered. What is the reason? What is the reason that he was denied the bereavement award? He was denied it because he didn't fall within the ordinarily resident, and he was denied it because he was not a British national or the other nationals that he could have fallen within. And so to that extent we say, well, you've heard my submissions on it being exclusive, and I rely on what is set out in the Skeleton argument. I think that begins at paragraph 56. But in addition, his nationality is also a significant part. And then we have the additional limb, if you like, which is the paragraph I took you to at 53 of the tribunal's decision, which is that by way of indirect discrimination, the ordinary residence feeds into that as well in its impact, which the Upper Tribunal recognises. And there's one other reference, actually, if I can go back to asking you to look at the Upper Tribunal decision that recognises this link, and that is at paragraph 67 of the Upper Tribunal's decision. And at paragraph 67, the point that Upper Tribunal Judge Ward makes is to say halfway down, specifically there was no consideration of it in the equality impact assessment, even without statistics, one may reasonably infer that the numbers of people in minority racial groups who are ordinarily resident in the UK, but whose close relatives are not, so that's our case, is likely to be significant. And then he goes on to say that isn't specifically addressed, which I think it's fair to say Mr. Moretto accepts. There isn't any specific addressing of that. For your reference, my lord, I don't need to take you to it, but whether weighty reasons, whether they come into play in a different way if the discrimination complained of is indirect or direct. You also have references at paragraph 188 of SC. And then Smith, your reference, I won't take you to it again because you've been taken to it a number of times, page 831, paragraph 39. These all make clear that whether it's indirect or direct, in fact those are indirect cases, the weighty reasons fall into play. The next point that I wish to, again, for your reference, I don't need to take you to it, but Mr. Moretto took you to Tijeri, and specifically, I think it was paragraph 33. Tijeri is helpful insofar as it does speak to the bright line, and when the bright line is an inclusionary one, or whether it's an exclusionary one, and that also is a matter that feeds into the assessment, and that is, for your reference, page 281, tab 9. My Lord Justice Lewis asked about what is the test, and on that in the same way that Mr. Moretto did, I rely on what is set out in SC and paragraph. We set this out in our skeleton, and it starts in SC in the judgment for your reference, and you've been taken to paragraph 158. But the importance of what is said about the manifestly without reasonable foundation is, to some extent, there's a distancing from it, because the focus, what Lord Reed said, is that actually a more nuanced approach needs to be applied, taking into account all relevant factors.
What does that mean? Does that mean that we put out of our minds the test of manifestly without reasonable foundation and simply do a fair balancing, saying this is the effect on the individual, that's the interesting question, and balance the two? Or do we do something that involves looking at manifestly without reasonable foundation?
But my reading of the judgment is that you insert into that the filter of allowing the margin, particularly as you're given, particularly as the legitimate aim here is a matter of economic policy.
So you insert into that, when you say insert into that, you insert into the stage 4.
Yes, the margin of appreciation.
By stage 4, I mean the fair balance.
Yes.
So when you're looking, you insert into stage 4. So you are looking at whether the balance struck by the legislature is without reasonable foundation, are you?
Well, through the lens of the margin of appreciation. So there's a much greater deference. But those factors, my lord, in my submission, there's an overlap in any event, because you're still looking at the context, the purpose, the impact. You're not putting those all to one side. And that's how you then come back to requiring that rationale, because if the rationale isn't there.
So I'm not putting them to one side, but am I asking, given these factors, is the balance struck by the legislature manifestly without foundation? Or am I looking at the factors and saying, I don't think that's a fair balance. I think it should have gone somewhere else.
Yeah, no, I think well, you apply the nuanced approach of the through the manifestly. You can't. It's with that margin. You can't remove the margin from the exercise.
Right. So I think then, from what you said, you're submitting that we must consider all these factors, the impact on the individual, the nature of the interest involved, and decide whether a fair balance was struck, in the sense that is the balance struck by the legislature manifestly without foundation.
But again, with that caveat of applying of deference to what those, if I put it this way, that there might be two outcomes applying the direct proportionality exercise, the balancing exercise, but because you're applying it through the nuanced approach of the margin of appreciation, that then meets the test, if you like. That's how I put it. And then, my lord, the other point that I wanted to, the references that I wanted to take you to, are within the supplementary bundle. That there's some information as to the awards that are made. So first, I can ask you to go to 3. It's 325. Sorry, it's 326, the top of 326, and you see there the number of total cases, it's 39,000. And that is to be read with 337, the top of 337, you'll see the fatality cases. So again, the reason why I take you to that is to highlight how small a cohort that we are concerned with. Yes, so I rely on those, and I think other than that, if I may just have a moment. Two final points, my lord. The first is just going on from Lord Justice Lewis, what you were saying about the manifestly without reasonable foundation. We say that that goes to the intensity of the review. I don't know if that clarifies what I've said previously and rely on what's set out in the skeleton. And the other point is following on from there being an absence of evidence addressing this, the point there to highlight is even within the duration of this litigation, there's been no further addressing of the impact or the if it's by way of any analysis of the finances or the data. And again, we set that out in our skeleton argument. There's been no witness statement or further indication as to the justification on that. So
I totally understand that submission. What are you saying has not happened, and how is it legally relevant?
The point, what we say has not happened, is there's been no further evidence addressing the consequences of the impact of tightening the eligibility provisions.
You mean no further evidence about the decision they took in 2012, or are you saying no evidence about what has happened since 2017 when the award was refused?
No evidence since 2012 or since the award was refused.
And why then is the evidence since the reward was refused relevant?
Well, because when it comes to justification, although we've addressed this in terms of post-decision justification, the point is that there is nothing, be it prior to the decision or post the decision.
No, I understand that. That's your first point, and you've now told me that there was nothing. You've not given any evidence, Secretary of State,
yes,
since the proceedings began about what happened in 2012. But you've also told me that they haven't given any evidence about further reviews or consideration that has been taken after 2017 about whether or not going forward to maintain it. And I'm asking you, how is that latter point legally relevant in an appeal against a judicial review of the refusal of the claim in 2017?
It's only legally relevant in terms of when coming to the proportionality exercise, whether there is anything to then have regard to. But I don't press that any further.
Good. Well, thank you. Thank you all very much indeed. We'll obviously take time to considered the decision. I need hardly say that whatever our conclusions are in relation to the legal matter, and those will be legal conclusions, we would re-emphasise, particularly for the benefit of your client and his family, that we don't lose sight of what an extremely sad case this is. You will know that the procedure from now on will be this. First, we look forward to receiving a joint note from you both. Would it be reasonable to say, within, say, 2 weeks, about the outcome of the funeral expenses issue? I mean, we would hope, obviously, that the note will tell us the outcome, but if it doesn't, that will be bound to be because it couldn't happen, because we fully accept that a good faith effort will now be made to deal with that matter speedily. It will involve cooperation from both parties. So may we note that we can expect to be updated within 2 weeks. Whatever happens with that, you'll receive our draft judgments. Those can be shared with people on the list, which is created for this purpose, which includes the client. And you'll please let us have your editorial corrections, any factual errors and slips, and also a joint document, please, setting out the proposed draft order to give effect to our decision. And if there happen to be any differences of view as to what that should contain, they can be dealt with in short written submissions. We won't need to trouble you to return to this court. And in due course, our decision will be published in the normal way, with account being taken of those suggestions. Is there anything else?
No, my lord, I'm grateful.
No. Thank you very much.
All right.